Hi, folks. I'm Rohit. I'm director for solutions in Tsaaro, and with me today I have Samraat Basu. We are both based out of Amsterdam, the Randstad area of Netherlands. Today, the topic for the webinar is key privacy considerations whenever a company takes over or merge with other companies. So M&As. But today we'll be discussing about the risk has and especially the privacy risk it has. Because when you're talking about acquiring a company, you acquire its assets, but also you acquire the liability. And the compliance part or compliance flaws also come as part of liabilities in it. So just a quick introduction of Saro. So about Saro, guys, we are a boutique consulting firm. We also have an academy. We are here in India and in Netherlands. We are set up there. We help our clients come up with setting up with privacy programs and ISO 27701. 27001. As for me, I am the director of privacy technology, and I also help my clients choose a privacy solution. Whether it's OneTrust, Big ID, Xtero, Security, Vanta, there are multiple of them. So depending on how the infrastructure of the client looks like, we help them choose the best one that is there. As for my qualification, I'm a computer science graduate from IIT BHU. I've worked with companies like Amazon, PwC before starting and founding Saro. As for the certifications, I am a CIPM and a Azure Solution Architect. So that makes me a man of both worlds. I can understand privacy and I can understand technology. We also have Samrat. Samrat, would you like to go and introduce yourself?
Thank you, Rohit. Like very briefly, I'm a lawyer specializing in technology and privacy, and I've been working in this domain for around 6 years now. I worked with Cyril Amarchand Mangaldas in India before moving to the Netherlands and specializing in tech and privacy. Did my master's at Leiden University. And currently, I work at Bol.com, which is the e commerce market leader in the Netherlands ahead of Amazon.
So thank you for that, Samrat. And as for the disclaimer, as you know, guys, this is a purely educational webinar where we do not represent our own companies. This is where would like to discuss things, but only on an educational basis. So moving on to our first slide. So this would be the agenda for today. We'll be discussing a lot about M&As and what are the processes, what are the major functions which is there, which are present there, and what are the risks there with respect to GDPR, with respect to CCPA, and with respect to Digital Privacy Act. So we also cover a case study to help you understand what exactly can go wrong. Moving forward, introduction to M&As. So, Samrad, you have seen multiple M&As, as you say, and your company itself is on a buying spree. So, would you like to introduce us to the topic?
Mergers and acquisitions. I'm sure a lot of you are already aware of what mergers and acquisitions are in the larger scheme of things. But maybe you may not be aware of the nitty gritties of what goes into an M&A transaction unless you've already been a part of a law firm or a private equity or venture capital fund where you've closely sort of seen either an investment or an acquisition, because a lot of times it may not be a complete acquisition or a complete merger, but it can be an investment of like a 20% stake or 15% stake into a company. I think Shark Tank is where you see how the broad discussion happens between co-founders and possible investors, but that's just the tip of the iceberg, because after that all of these steps sort of come into play in a mergers and acquisition transaction. So the first thing is to develop a acquisition or a investment strategy for a investment fund or a private equity or venture capital fund, or maybe a company like my company, which is looking to gather expertise in certain areas and sort of integrate that within the larger ecosystem. So, for example, this is something that I worked on not for my company, but back in India when I was doing a deal for Amazon in India. So, they were acquiring a billing software company, which they would integrate within their checkout process. So that's one strategy that you can adopt. Okay, what are the different areas in which I can improve my company, improve efficiencies, and make things smoother for our customers, and generally, so that our customers have a better experience. So that's part of developing a strategy. There can be numerous different strategies that are involved. So once you develop a strategy for acquisition or investments, then you have to identify which companies are playing in that space and are operating in that space. Once you identify that, then internally you'll have to evaluate. You'll have to go and look at their products, look at their services, see what kind of prices they're charging, and who their customers are, or if it's a high growth company. You have to look at all of these different factors and evaluate it yourself.
As you mentioned, we were talking about a lot about compliances and risk. So, what are some of those potential risks? That would be wonderful to know, Samrat.
Yeah. See, there are a lot of risks, and we are focusing on privacy today. But obviously, for any company, there are so many different areas that need to be poured through different experts. For example, there can be corporate law issues or labor law issues, or there's a host of different issues that typically come up. But with regard to privacy, privacy has become an increasingly important role because of super high GDPR penalties, and also the amount of data that most startups now collect in order to better optimize their performance, and their products and services. So data is one of the key elements that are moving any business forward today. So therefore, personal data risk and privacy risk becomes one of the most important diligences that need to be done by any company or startup going forward. And some of these risks are, the risk of data breaches. And I think later down the slide we've discussed the example of Marriott, where they acquired a company, hotel chain, and sort of integrated it within their fold, except there was an ongoing data breach of their customer register. So a lot of sensitive personal data of customers, who stayed in Marriott, was leaked, and also not just sensitive but regular personal data such as email IDs and um, you know credit card details, and so on and so forth, were also leaked. So data breach is something, and that resulted in Marriott having to pay a huge fine because of this acquisition, which was more than what they paid for the company's personal data. So these are some examples that happen with engineering teams because they think that they have put in place a system, but that system may actually not work in practice.
So, here's a minty question for you guys. What are the potential consequences of failing to address data privacy issues in an M&A transaction? So, guys, it would be all of those because all of them will be tainted, and it would become the company. It would become very difficult for the company to even move ahead if it's this is caught in the due diligence. I would move on to the next slide. That is the steps to conduct a privacy due diligence. So we were talking about what can happen, what can go wrong, and a business perspective. Now let's talk about the process to how to realize it.
Yeah. So the first thing that you need to do is actually understand what data you have in your system, and what like different teams have different data. So like, to just basically start off from a company perspective, the first thing that you'll have is you will have people working in the company. So right, so you will have employee data. That's the first thing, and a lot of people just focus on customer data, but they forget about employees. And so the first type of data that you'll have is data related to your employees. Then you'll have customer related data. Then you will have data sets in with vendors, or sellers, or different like software as a service that you use, because you're putting your data in that software and using that service, and maybe there's more data being inputted through that service which is flowing into your business. Once you do that, once you review existing policies and figure out how you're doing all of these different things, you have to assess data flows to vendors, to customers, from vendors, within the country, outside the country, within different jurisdictions. So you'll have to take a map of, okay, what the different data flows are, and then you need to figure out which countries it's going to, what the data protection laws are in those countries. So once you figure all of that out, then you need to evaluate your current measures and see, okay, should we change the policy? Do we need to change the policy, or do we need to make any adjustments?
Thanks, Samrat. I'll move forward. So, compliance concerns in M&A. We
Yeah.
talked about what are the stages, and we also talk about some of the risks. But what are the compliance concerns? And can it be like something which we can cover in the due diligence itself?
Yeah. So as I said, the first concern that I see is that a lot of business teams misclassify data. So instead of classifying it, if you're looking at the GDPR as personal data and sensitive personal data, they will classify it as PII one, PII two, PII three, so on and so forth, which is the first concern issue, because then now everything else goes out of whack. Then once that is done, the second area of concern is consent and the ground for processing. What is the ground? Is it performance of a contract, consent, legitimate interest, or required by law, such as you may need to keep data for fraud prevention. So sort of understanding what purposes different data sets are, and even the same data set is being used for, is business critical. And once you understand that, it's important to understand who you're transferring this data to, and what their policies are, and what is the risk of exposure, because then you become the controller and the person processing it becomes the processor. So and managing that exposure and risk to exposure is very important.
So, since we were discussing a lot about GDPR, so I think so. Let's also talk about what are the statutory requirements for GDPR in an M&A transaction.
Yeah, I think I've discussed some of them, so I don't want to waste time going through them again, such as transferring data. So you're transferring data, you need to conduct a transfer impact assessment. But lawful basis is something I've discussed as well. Data subject rights is very important. Data subject is, a lot of people may not understand what a data subject is. It's basically your customer, who's the data subject. So data subjects have a right to be given information about a processing activity in under Article 13 GDPR. There's a bunch of information, what data is being collected, what is being processed, what has been transferred. So what I do know is that the CCPA is important, because a lot of these tech companies are based in Silicon Valley or Delaware, basically American states, and America does not have a federal privacy law. So every different states can enact different privacy laws. So if there are companies which are based out of California, the CCPA will apply. But most of these tech companies are based out of Delaware and not California. So this is important to know, because people think that, oh, California privacy law, so then our privacy will be better protected. But that's actually not the case, because we can go through what the law says, ye hai, wo hai requirements, but it's actually meaningless, because most of these tech companies are established in Delaware and not California. They may have offices in California, but their establishment is in Delaware. So that's just something that's important to understand. Key, what is the applicability of the law? And I'm not sure. Maybe the CCPA will apply to the entire country, but I don't think that's the law. California privacy will apply to California companies, is my understanding.
So that huge is California. So it's not something, but yes, we are waiting for. There are multiple states which have taken action and are ready to move towards a privacy law. But yes, there is no federal privacy law there in US. So for
Yeah.
now, we normally take CCPA and CPRA as the de factos which are prevalent in the states, and compare it with the GDPR. But GDPR has much more wider implications. So, Digital Services Act, I think so. This is something you're very passionate about, Samrat.
Yeah,
So,
it's not something that I'm very passionate about. It's something that is keeping me up at night, because are higher than the GDPR. It's 50% higher than the GDPR, which is saying a lot. And there are very, very strict requirements, and they are linked to data and privacy. in some ways, but in other ways they're quite different. But they're also now going to be very important for M&A transactions going forward, because the Digital Services Act will come into force next year, early next year, I think January or February next year. And there are a lot of different aspects which I think lawyers or technology lawyers or anyone who has an interest in tech or privacy should be aware of. And the first one of them, which sort of interlinks, is a ban on dark patterns. And this is something that we've seen in cookie banners for a long time, where you're given this cookie banner, and then you can accept all, and the accept, or you can have more options, or reject all. Sometimes reject all button is not there only, but if it's there, then there'll be different color schemes to sort of make you like move towards the accept option, or whatever the option is that the company wants.
So then they will have to standardize certain workflows and very explicitly point out those dark patterns which cannot be followed. And
Yeah,
especially in terms of color schemes, then we'll see some of them being templatized.
yeah, yeah. It has to
So
be the same. It can, the colors can be there, but every option, at least every button, has to be of the same size and same color, because otherwise it will violate the Digital Services Act, and there's a potential of 6% annual turnover penalty.
so here's your favorite part, Samrat. That is the case study. I think so. You have covered. You have spilled the beans on that a
We are
few
shorter,
slides ago.
you can skip it. Yeah, I mean, it's the Marriott
Yeah,
case.
but let's go again through it because I see um, some people joining in a bit late. So let's
Okay.
discuss this quickly and then we'll move forward.
Yeah. So basically, Marriott, acquired a hotel chain called Starwood, and they did diligence, but privacy diligence nahi kiya, basically back in the day, because this is back in 2014 or something, around then. So this is before the GDPR came in. But ये breach continuing हो रहा था, right? And before this breach was discovered in 2018 after the GDPR came into force. Just for context, it came into force in May 2018. So there was an ongoing data breach which no one knew. GDPR comes into force, then suddenly all the lawyers are like, oh, the GDPR has come into force. Now we need to fix our systems. And then once doing this, they discover that, oh shit, there's this huge breach which has been going on since 2014. And then obviously the Information Commissioner's Office, which is basically like the data protection authority in the UK, they fined them 18.4 million pounds, I think, for the breach. And on top of the fine, all of the customers whose data was breached sued Marriott, because obviously, they may not want their information that they were in a certain Marriott or Starwood hotel at some point in time to be disclosed and made public. And because this breach was ongoing, their privacy was obviously affected, and they had rights under the GDPR. And so all of them got together and started class action suits against Marriott, which I believe is still ongoing. So yeah, it's very important to sort of do a privacy due diligence. I think in India also we are in that sort of situation where the law is still not there, but people are like, "Ha, it'll come." But if you don't start managing your systems from now, and that's where Tsaaro can obviously help. But down the line, once the law comes into force, if you start putting your teams together and start figuring out, what are we doing, where is the data going, what do we have, what the rights are. There are so many of these different nuances, like children's data or dark patterns and so on and so forth, or which you won't even realize that you're breaching for months and months or years and years after the law has come into force. So it's important to be proactive and pragmatic and start sooner rather than later.
Now we'll be discussing about two things. So two most important scenarios are pre-closing a deal and once you're done with the deal, that are the post closing operations. So we'll discuss the pre-closing ones first, and then we'll discuss the post-closing ones.
Yeah, so the pre-closing activity is things that need to be fixed or done before the deal is closed, the papers are signed, And the first pre-closing activity is conduct the diligence and figure out what the issues are. And then once you figure out the issues, then sometimes time is given to companies to, okay, fix whatever small issues you have. We will give you 2 weeks, we'll give you 3 weeks, we'll give you a month. And that's when they will start go into top gear and try fixing these issues, because they don't want a purchase price reduction, right? So they will be working on different contracts or policies, and fixing all their internal systems. But a lot of times internal systems are not fixed, so pre-closing, the biggest activity is a change, whether upward or downward, of the purchase price of the asset. um, so I think that's the most important pre-closing takeaway, that if you don't do a privacy diligence properly and fix your issues, then there can be a huge difference in the purchase value uh, of your company. Consent needs to be taken in a lot of situations for the M&A transaction itself, because you're giving access to all your data sets, all your files, to a third party who may or may not buy the company, right? Their entire group of lawyers, the entire company is getting access to all your data, all your information system, all your privacy policy, everything, right? Because that's just how diligences are. So sometimes it may come under legitimate interest, but sometimes you may need to take consent as well from your customers. And you may want to do that from a reputational point of view, saying that, okay, we're looking for investment, so we need your consent. A lot of times, if consent is not given, then you need to use legitimate interest, because otherwise the deal will not go through, right? So yeah.
I think so. We have covered interesting cases here.
Yeah.
So we by this we come to our last questions. What is the role of privacy policies in an M&A transaction?
So yeah,
So
I think there are a few questions. I think just two. So maybe I can answer them before we close.
yeah,
So someone has asked any landmark case on dark patterns from where this term originated. So I've put a paper which you can read for further information. But there's no case law as such on dark patterns, because it was not outlawed. Now the Digital Services Act is saying that dark patterns is illegal. Therefore, if someone violates, there will be case law going forward. But because before there was no law at all governing dark patterns, there's no regulation. Therefore, there are no case laws, and therefore it's perfectly legal right now to have dark patterns. And that's why so many websites use dark pattern without any consequences. So that's one. Two is someone has asked, please enlighten on mergers and acquisition in Indian context, the applicable law. I understand GDPR and CCPA, etc., are not for India. So yeah, so whatever we've discussed regarding privacy concerns are obviously from a European and American perspective, but understand that so just to give you some background, I was part of the committee, Justice Sri Krishna committee, and I helped the committee draft India's data protection law. This is 5 years back. Obviously, for the last 5 years, there have been a lot of um, back and forth and changes. But the core of the law is very similar to the GDPR. So if you understand GDPR, then you already know Indian privacy law. Of course, there are changes and there are adaptations, and in 5 years there have been a lot of different debates and different lobbying efforts by different groups. So there's a lot of back and forth happening. Like, I won't be able to name the companies, but again, an interesting story is that some of the biggest companies in India are getting into the data center business, and they want data to be localized in India. So data localization was a very big issue. But obviously, as you can imagine, a lot of big tech companies don't want data to be localized in India, because they want to transfer their data to America or Europe or wherever their servers are, because there are servers everywhere for more efficient and quicker processing. So now there's a group of tech companies and their lawyers and their policy analysts, lobbying ki, localization hatao. And there's a group here of again powerful companies in India and also international companies. Like you can imagine which companies provide data center services, lobbying saying ki no, we want local data localization in India. So now iske beech mein law is being debated, which is why for 5 years nothing has happened.
Because
For
this became a very prevalent, would not call it gossip, but yes, a talk topic within the PVC professionals of India, that
yeah,
why the bill was not passed and it has been stalled multiple times. So this was one of the reasons. This is seen as one of the opinions, I would
yeah.
say, for the people.
And like I was one of the lawyers lobbying, so I know this is actually happening. So this is not hearsay. This is before I moved to Europe, so this is 3 years back.
I
Yeah,
know it has been a long session, but it was a very interesting session. And Samrat, thanks for giving us so many insights and so many small stories that we can take and learn from. And we also have new laws coming in, and I hope these will make our lives better, because essentially privacy is a people's act. It's a something that empowers the citizens. So let's see how it rolls up. Bye guys, thanks for joining us.